Three against one.
So I'm Amy Gilligan. I'm the executive editor at the TH, and happy to have you with us today. My colleagues, let them jump in and introduce themselves.
Yeah, hi, Richard. I'm Bob Woodward. I'm the publisher of TH Media and Telegraph Herald, VP for Woodward Community Media. Thanks for joining us today.
Hi, Richard. I'm Mike Fortman. I'm the associate publisher for TH Media and the group director of advertising for Woodward Community Media. Thanks for joining us.
Okay, sure.
And if you would just start out telling us a little bit about your background and the group you're representing today, and kind of how long you've been affiliated with that group.
Well, to get on the record, my name is Richard Rogers. I'm a board member, longtime board member of Iowa Firearms Coalition, and I serve as the volunteer lobbyist up at the Capitol for the last 8 or 10 years. It's pretty much a full-time volunteer job. I joined our predecessor group, Iowa Carry, back in January or February of 2008. That was a group that was organized. It started out with about 4 guys that were doing, frankly, they were meeting at a coffee shop and grousing about the old law we had where the sheriffs had absolute discretion on issuing permits and putting restrictions on permits to carry and so on. One of the members had come up from Virginia where they had pretty good laws, and they were upset because in their county they weren't able to get a permit to carry. So they had their little coffee klatch and they expanded it into an internet bulletin board system, and then eventually became Iowa Carry, just to change the law on weapons permits. Once that happened in 2010, it went into effect January 1st, 2011. Our group had to decide, and I had joined in 2008 because I could see they might well be able to get something done, and I wanted to participate. So I joined as a life member at that time. So in 2010, we had to decide whether we wanted to, having accomplished our goal, we wanted to drive and blow away, or whether we wanted to expand our mission and become a permanent organization rather than an ad hoc organization. And that's what we did, and formed Iowa Firearms Coalition, and we loosely affiliated with the NRA at that time. We are all volunteer group, all grassroots, but we're not a subsidiary or part of NRA, but we were an affiliate. And then about 3 years ago, I can't give you the exact date, we did become the official, NRA chose us as the official state club for NRA. So while we're still an independent group, we serve as their official state club. So we are now in charge of organizing NRA competitions and things, as well as doing our work with lobbying and education and so on.
Okay, and tell us a little bit about this measure that voters will see on their ballot this year, how it came to pass, and what you think is the importance behind it.
This is an amendment to our state's constitution. It's actually going into our state has its own Bill of Rights, and this will be in the Bill of Rights. This came about, we call it the Freedom Amendment. That won't be on the ballot, but we, in order to market it and to refer to it, we call it the Freedom Amendment. So in 2010, when the shall issue weapons system scheme was enacted, we realized that Iowa was one of only 6 states in the nation that doesn't have any protection for the right to keep and bear arms in our state constitutions. And frankly, it's a club we don't wish to be in, I don't believe. California, New York, New Jersey, Maryland, and our neighbor Minnesota and Iowa. It seems perhaps we don't fit in that group. So and at that time, remember that the Bill of Rights was never intended to apply to the states. And it's only been since the Civil War and the adoption of the ratification of the 14th Amendment that the Supreme Court began over more than a century to incorporate aspects of the Bill of Rights against the states. Incorporating against the states means that the states have to observe those rights. They did not do this in the case of the Second Amendment until 2010 in the Chicago versus McDonald case. So about the time we were considering whether we could get some state level protections in our Constitution, the Supreme Court did say the states and their political subdivisions have to abide by the strictures of the Second Amendment. However, as you know, with court cases, it takes years to develop the jurisprudence surrounding a new decision like that. frankly, in the Heller decision in 2008, in which the Supreme Court verified that this is a fundamental individual right. Well, it was already a fundamental right, but an individual right. And in 2010, in the McDonald case that said the states have to abide by it, recognize it, they did not give clear guidance to the lower courts on how to review cases that involve Second Amendment issues. So we determined at that time, we knew this would be a long battle to get this in the Constitution. In the best of times, it takes several years to get it through 2 separately elected General Assemblies and then before a vote of the people. And we knew there'd be opposition. We didn't know how long it would take, but it was a long battle, and we had to commit with our allies at NRA and who are having issues of their own that we didn't foresee at this point, but at NRA, with our legislative allies and with our own leadership group, are we in this for the long haul? And we determined we are. And so this has been our #1 priority all these years, even while we helped persuade the legislature to do the right thing and change a number of our laws in Iowa regarding weapons permits, use of force laws, and so on. Even while we did all of that, our #1 priority was to get this protection in our state constitution. The first version of this was passed by the Iowa House in 2011. I don't recall the exact language. I'd have to look it up, but it was quite similar but different. It passed through the Iowa House in 2011, and Senator Grunstall, Mike Grunstall, was in charge of the Senate at that time, and it did not move in that year or in subsequent years. So we have passed it through 3 separately elected General Assemblies now. Now, as far as the language goes, I didn't write this. I'm not a lawyer. I didn't write this. Our Iowa Firearms Coalition team didn't write this. The NRA didn't write it, but pardon the phone there. But there were lawyers in the legislature who helped write this and put the strict scrutiny in here because they were concerned that the courts needed some direction.
Okay, and so why do you think this wording is important versus just something that mirrors the Second Amendment? It seems like a lot of states have something that sounds more like the Second Amendment than to add the strict scrutiny.
Actually, I've reviewed those not for quite a while, but there is a fairly wide variance, and some of those provisions in state constitutions actually precede the founding of our nation and the establishment of, or precede the U.S. Constitution anyway. So sometime during the colonial period or the Confederation of States, they adopted that. Many states adopted this when they originally adopted their constitutions. Other states added it as amendments later. And in the case of a few states, such as Louisiana, they had a provision in their constitution and then later amended it. So there are 3 other states that have strict scrutiny because they've amended it in recent years. The strict scrutiny, I believe that was your question, is why the strict scrutiny? We believe that the right to keep bear arms is a fundamental right. It derives directly from everyone's right to life. The right to keep bear arms is merely the right to pick up a tool, be it a rock, a 2x4, a stick, a firearm, a sword, whatever, and defend your life, that of your family, the safety and integrity of your community or your state, or your nation. So it's a fundamental right, and the courts have long recognized that, going back to the 1800s, that it's a fundamental right. The tiers of scrutiny, rational basis, intermediate scrutiny, and strict scrutiny, were established beginning in the late 50s, I believe, and developed over time. And strict scrutiny is the standard of judicial review that courts use when looking at fundamental rights such as freedom of speech, freedom of religion, the right to equal protection under the law. Why would you want to treat Second Amendment rights, hold them to a lower standard? What other fundamental rights do you have that you would wish a lower standard of judicial review be applied to. In 2011, I remember sitting in the first committee hearing on this, and a couple of legislators who have not voted for this, but who did hold some common beliefs with us about the right to bear arms, said, well, why don't you ditch this language and adopt the language of the Second Amendment, straight across. And then we could support it in committee, and we think we could get enough votes from our side of the aisle in the House, this was a House committee, to pass this. And my view was that was a trap. Those who oppose our free exercise of this fundamental right have tried for over 100 years to get around the clear language of the Second Amendment. Pardon me while I clear some notes on it. They're obscuring my screen here. They've been trying to get around the clear language of the Second Amendment, and they've been pretty successful until recently. So we learn from mistakes, we learn over time, and we chose to give this direction to the courts because, again, a fundamental right, that's the appropriate level of review for fundamental rights.
Has there been legislation in the state that has passed that you feel chips away at that fundamental right that maybe something like this would prevent? Well,
over the period of when we started as Iowa Carry, typically 28 to 30,000 Iowans across the entire state had a permit to carry weapons, and you had to have a permit to carry weapons to carry it in town, within the city limits or in a vehicle. That's a pretty severe restriction right there, but it might pass. When we got shall issue, but the thing was, it wasn't equitable because the sheriffs had absolute discretion, and so some sheriffs wouldn't issue at all. Some issued to their donors and friends. Some issued, literally, a couple of sheriffs were issuing permits that had so many restrictions on them that they were absolutely worthless, but they cost $10 a year. And a person who had that may not understand the restrictions and would get in trouble with it. So it varied greatly across the state, wasn't generally accessible to people, and therefore it was inequitable. So that was my fight. I joined as a life member, even though I lived in Polk County, and I'd had a permit since I turned 21. Of course, the sheriff could have changed that any day he wished, or he could stop issuing altogether. And the sheriffs changed over time, and the rules changed over time. Every year I'd have to go down and they periodically would change the rules. I continued to go down and jump through those hoops because it was a matter of liberty to me. Not that I felt like I needed to carry a gun all the time, but I needed to protect this right, access to this right. When we went to shall issue, which went into effect on January 1st, 2011, that first year we had 101,500 plus permits to carry issued. At last count, which was early last year, we were at around 425,000. And that, by the way, is the third highest of eligible adults, third highest percentage of eligible adults in the United States. So we've completely changed the landscape, and this is much more accessible to people. And in fact, on July 1st of last year, the requirement to have a permit to carry weapons was repealed. So we feel that Iowa laws are in pretty good shape. We've worked over the years hard to right the ship, as it were, where before you had to appeal to the state in order to exercise your fundamental right. And now the state has to have very good reason to deny you exercise that fundamental right. And that's the way it ought to be. But what we're concerned about mainly is every year bills are introduced into the legislature that mimic laws in New York and California, Maryland, places like that, where they seem to have a contest every year to see what new original ideas they come up with to further restrict the lawful possession, commerce, and so on in firearms. And by the way, the right to keep and bear arms is arms, not firearms, not guns. In the past, that might have been a bow or a spear or a sword. In the future, it might be a Star Wars phaser or something like that. So it's not strictly guns. And I don't particularly care for the appellation gun rights, which I see you used in your story yesterday, which I was quoted. It's common. People on our side use it all the time, but we don't refer to it as gun rights. Guns don't have rights. We have civil rights. We have basic human rights, fundamental rights. This is a matter of liberty to me. I think I got off on a sidetrack there and forgot where
That's
we were.
okay. The wording on the ballot doesn't talk about gun rights protections?
The ballot says the right to keep and bear arms.
Okay. Okay.
The amendment. This will be 1A. Fittingly, this will be the second item in our Bill of Rights in Iowa. There's Section 1 and then Section 1A, and the first part of our Constitution says Bill of Rights. The right of the people to keep and bear arms shall not be infringed, and that's a quote directly from the Second Amendment.
Mm-hmm.
Then Iowa recognizes and affirms this right to be a fundamental individual right. So that echoes the understanding since Heller that it is an individual right, and there was a previous understanding and referred to in Heller that it's a fundamental right. And then do we get to this controversial bit about the any restrictions of this right shall be subject to strict scrutiny. And frankly, some people on our side don't quite understand that either. They think we're opening the door to allow for infringements on the right.
Yeah, probably some confusion on both sides about what that means.
But what we tell them is that, let's say you have a concern that a government, local or state government, is infringing on your right to free speech or your right to practice your religion. Well, if you believe they're infringing on you, what are you going to do? You're going to go to court. In a court, a judge or jury is going to review this and make a decision. Is the government right or are you right? How do they do it? What's the framework for that review? And that's all this is establishing that they're required to use the framework for this fundamental right, the same as they use this framework for rights of free speech and religious one. Here's the problem: that since Heller, I mentioned that in Heller and McDonald, the Supreme Court didn't instruct the lower courts on how to review these cases. And so the lower courts have said, when they have a Second Amendment issue, they said, we're using intermediate scrutiny. In most cases, it ended up being actually, I think, a lower bar than that, closer to rational basis. But in intermediate scrutiny, they just have to say the government has an important interest here, and this is substantially related to that interest. And they gave all full deference to the state and local governments that had, or sometimes the federal government that had established a restriction, and little regard for the fundamental right. Now, I would point out that in Justice Thomas's great decision in New York State Rifle and Pistol Association v. Bruin, New York State Rifle and Pistol Association v. Bruin, on June 23rd of this year, he has long said in other cases that the Second Amendment right is not a second class right. He reiterated that in that decision. But he said that the Second Amendment, the statement shall not be infringed, this right shall not be infringed, the right to keep bear arms shall not be infringed, is an unqualified command. It's an unqualified command. Frankly, as I told your reporter the other day, I think that this strict scrutiny that our opponents to the amendment are so concerned about is kind of moot since June 23rd, because the courts have been ordered to use a different, and I believe a more difficult standard, and that is the area of action that, whatever the controversy is at law in a case, is that covered by the text of the Second Amendment? And if it is, the only way it can be restricted is if you can show that there's a same or an analogous restriction back at the time of the adoption of the Bill of Rights. And that's a very high bar, but that's the new standard, and it's shaking up in state and federal courts, lower federal courts. It's shaking up the whole area of Second Amendment jurisprudence right now. It's going to take a while to shake out, but I think that the strict scrutiny is, frankly, I say that this is a belt of protection in our state constitution in case the suspenders of the Second Amendment fail. As long as the new and current understanding of the Second Amendment at the federal level holds, and nobody packs the court if they don't alter or overturn that decision, I don't think this strict scrutiny is really going to come to bear very often.
So with something like some of the states have talked about red flag laws, a law saying that a person could lose their gun rights if they were deemed to be a risk to themselves or others. Would something like that not be able to meet that measure, do you think?
Well, the courts will have to decide that, but I think, frankly, that the largest problem with red flag laws is being unconstitutional because they don't provide due process, which is not a Second Amendment right. It's Fourth Amendment right, but there are some other problems with it. The courts will have to determine that. I do not believe that there will be a valid challenge to laws against, for instance, minors, felons, violent felons in any case, or those who have been adjudicated as mentally deficient, because those are long-standing traditional rules of society. We've never allowed the full and free exercise of such rights to certain categories of people, and basically violent criminals and those adjudicated mentally deficient, and to children. So I don't think those will come into play. They have been challenged. I think in Louisiana there was a challenge to the felon prohibition on felons possessing firearms, and at a lower level it was overturned, and then it was immediately that was reversed, and it stands. I do think that our Chief Justice Amy Coney Barrett has said in her previous judgeship that it's questionable whether a person who has a 25-year-old check kiting charge, a felonious check kiting charge, ought to be prohibited for life from possessing firearms. So there are questions like that around the edge. But as far as the traditional violent felon being able to possess firearms because we have strict scrutiny, no, we don't believe that's a problem at all.
Is that what you're saying there? Is that what the NRA, is that their belief as well, that they wouldn't necessarily be trying to challenge those things that have been in place to limit the availability of guns to minors or felons or the mentally?
I can't, of course, speak for the NRA, and when I speak with the NRA, I'm dealing generally with their lobbyist or state director for Iowa and some other Midwestern states. But I've had no indication at all that the NRA had any intention of challenging some of those longstanding prohibitions. That doesn't mean others won't. But again, I don't think there's really any basis to fear that for instance, the prohibition on felons possessing firearms will be reversed. At least maybe at some point, that because it's already been brought up in court cases, as I said, by one of the Supreme Court justices, or possibly two, that question whether a nonviolent felony, long-standing in the past, and the guy has a stellar reputation since, whether that's a fair penalty. So that could come into question. But talking about a murderer getting out of jail and like in the old westerns, and his friends ride up and his fellow outlaws ride up and hand him a gun and a holster. No, I don't think that's going to become legal based on strict scrutiny.
Mm-hmm.
So
or even under Justice Thomas's mandate.
So Richard, one of the things that I hear for people both who support and who don't support the right to bear guns is, yeah, I can get that you want guns that maybe that can protect yourselves or to go hunting with and things like that. But they question the need for assault rifles. And I get that that's a personal choice and so on and so forth. But I think there are a fair number of people on both sides of the issue that say we should have some restrictions for guns. Not saying we're coming to get your guns, but I'm just curious how this plays into that whole discussion. First
of all, you mean so-called assault weapons, because true and assault weapons is a made-up term. If you're talking about assault rifles are an actual thing. They're using an intermediate power cartridge in a select fire rifle, so you can have semi-automatic or full automatic. It's used by the military around the world. Those are highly regulated in the United States. They're not outlawed, as many people believe. 1934, machine guns, fully automatic weapons were highly regulated by a tax law. In order to have one, you have to register it with the federal government. Otherwise, we don't have gun registration in most of the U.S., just in a few jurisdictions. But these type of weapons and short-barreled rifles, short-barreled shotguns, and suppressors, firearm silencers or sound suppressors, have to be registered with a serial number of the federal government. You have to give them a couple of pictures, passport pictures. You have to give them 2 sets of fingerprints. You have to pay a $200 tax on each item. In Iowa, it's not legal for citizens to own full automatic weapons, which an assault rifle would be, unless they're a manufacturer or a dealer to law enforcement or military. So that's it. Assault weapons and naming things that aren't technically select fire weapons, calling them assault rifles or assault weapons, that's a tactic reaching back to the 80s. I believe Josh Sugarman, and I can't remember because they changed their name frequently to the group. It was originally the Campaign to Ban Handguns. They came up with this and said, to paraphrase, we're going to use this because in the public's eye, something that looks like a machine gun is a machine gun. And they admitted there are Campaign to Ban Handguns, which is the weapon used in most firearms murders or deaths, suicides, that's a failure. We weren't able to ban handguns. So we're moving on to restrict guns, and we're going to, anything that looks like a machine gun in the public's mind is a machine gun, and it was brilliant. It's worked great, and the media has been complicit with it. I see that the AP style book recently has sort of backed off on that and said, well, you really don't want to be talking about assault weapons if that's not what you're really talking about. And I think the reason for that is that the AR pattern rifle is the most popular firearm in America now. Not because it's a weapon of war, but because it's modular and adaptable, and it's useful for so many people and different body types. You can find them where they're adjustable. By the way, they are used for hunting, and not just for coyotes and varmints and things, but an AR pattern rifle can be adapted to many different cartridges. And so we have people here in Iowa who have gone out and bought AR type rifles that shoot what used to be considered maybe a pistol cartridge that is legal, high powered, relatively high powered pistol cartridge, and it is legal for deer hunting. The last few years, it's been legal for deer hunting. So it's very adaptable, and that's why it's so popular in large part. People that don't understand guns don't understand that. If you have the old model of a blued steel barrel in action and a beautiful walnut stock, it's very difficult to modify those type of guns. And the AR pattern rifle, way more so than the Russian AK rifle, is exceptionally adaptable, and thus it's the most popular firearm sold now. So there's absolutely valid reason. They're commonly held. The Heldred said if it's a commonly held, commonly possessed firearm, it's legit. We're not going to restrict those. So they have problems already in the law, disregarding strict scrutiny. We don't agree.
Richard, I have a question for you.
I would say we don't. A ban on a type of firearm would fail either the Supreme Court's test or our test, I believe, and that's already proven true in California, in the Ninth Circuit, and so on. Those decisions have been sent back down in the light of the Bruin case, but that's developing law now. It's going to be reversed. Circuit courts have upheld bans in certain areas on these so-called assault rifles, but that's not going to last. Go ahead, sir. Sorry.
Yeah, just getting back to the amendment here for a second. In light of the fact that I know you mentioned that Iowa's only a handful of states that don't have any protection at the state level for the Second Amendment. I think you mentioned there's 5 of us or something like that.
5 others.
But there's only 3 who've adopted the strict scrutiny verbiage, which some people say takes the Second Amendment to a higher level than even the Second Amendment. And given the court case at the federal level that was setting precedent this summer that you think makes a stronger case for in general anyway, I guess why not join the majority of states and have an amendment that mirrors the Second Amendment at the federal level? And as you mentioned, I think they've already determined that that federal Second Amendment applies to the states. So why not just do that rather than going to that extra level of the strict scrutiny?
Well, because when we started this project, that almost at exactly the same time was when the McDonald or the Chicago versus McDonald case was decided, and the Second Amendment was incorporated to the state. So that had just happened, and there was no direction. In addition, the lower courts, it was obvious immediately, had not seen to follow the dicta of the Heller case and really honored Second Amendment rights as a fundamental individual right. They continued to allow, using this intermediate scrutiny of it, probably really a lower, closer to rational basis review, they continued to allow rules that clearly infringe on that right. As Justice Thomas has now said, it's an unqualified command, shall not be infringed. And you have to go back and understand that if the founders, when they adopted this language to the Bill of Rights, if there were existing restrictions at that time, then those are considered to be acceptable because they knew, okay, well, we do this, we say this, but we're doing this as compatible. Frankly, with the newest understanding of the Second Amendment in the Bruin case in June, we may not need this in here. But as I mentioned before, we refuse to just adopt the language of the Second Amendment as was suggested by those who all voted against this amendment, because we felt that was a trap, that there were far too many infringements of this unqualified command, violations of this unqualified command in existence, and we wanted something more direct. Now, the reason only 3 states have done it prior to us is because most states haven't felt the need to. They have protections, and whether they're properly observing them or not, they didn't feel the need to go through the process. Also, in some states, it's a much easier thing to do. In Louisiana, for instance, you can get in Florida, you can get an amendment through in 1 year. It's quite a long process here, as it should be. But
I know that we're talking about a document. The Second Amendment was literally written a couple centuries ago, but do you feel that there's ever a time when situations change because of the prevalence of gun violence, where
violence? It's violence. The guns aren't causing it.
Understood, but they're being used in that violence, and they sort of are a tool, as you mentioned earlier. So, does this I guess I would say negate the opportunity at some point to revisit the issue anytime soon or ever if there is a need or a desire?
I believe that the right to keep and bear arms evolves directly from the right to life, as I mentioned. The right to keep and bear arms that are in common use, individual arms. I'm not talking about crew-served weapons or nuclear weapons, things like that, but things that people can use. They can either use them to defend themselves or their family. They can use them to join the militia, join the posse. These are rights that pre-exist the Constitution. Read Heller. And Heller only refers to cases going back into the 1800s. The right to keep and bear arms pre-exists the Constitution, does not depend upon the Constitution for its existence. The Constitution does not grant us that right. It seeks to protect the right. The protection of it, in my view, was failing over the last 100 years. The Supreme Court has now, in 2008, 2010, and 2022, so it was 14 years since Heller, has now elevated the protection of those rights, those pre-existing rights, to its proper place. I hope it shall always be so. But as I said, this right in the future, if enemies of the state and enemies of your family, in other words, criminals, street criminals, have Star Wars type phasers, then the individual citizen will be allowed to have a phaser. In the past, we had swords and dirks and, you know, long spears, bows and arrows and things. Some of those were more effective for individual defending their property than others. Some of it was more of a military thing. But you go back to English law, going back centuries, they recognize this right, and it's not a collective right; it's an individual right. But we sometimes collect this citizenry to defend. Now, we've seen over the last century terrible instances of dictatorships, tyrannies, and one of the first things that a would-be tyrant would do, or a government that wishes to act in that manner, is to eliminate the means of resistance from those that they would have be subjects. You know, the history of man is not a history of individual liberty. It's a history of subjugation by those who seek and seize and hold power. And once your means of defense is taken away from you, it's very difficult to recover it or to resist. So Americans never felt they had to worry about a tyrannical government. They didn't even have to worry too much about crime on a personal basis. Some of that's changing a little bit. But our fear is, well, my view is that as long as we have access to weapons with utility, then we should not have to worry about ever having to use them against anybody in our own country, other than, you know, the random criminal or a riot, or you know, we hopefully we won't have to repel invasion at this level. But if we give up that right, it makes it very difficult to, you know, the human nature is such that people seek power. They seek power over you.
Sure.
It's slavery. You become a
I
slave.
understand. Again, I guess
that's the ultimate reason for this Second Amendment.
Right. Thank you.
Well, Richard, we really appreciate you meeting with us today and giving us this perspective. Anything else that we should know before we let you go?
Well, we believe that the people of Iowa will ratify this amendment. That we'll have a good majority. We need 50% plus one vote, but you know, we're hoping for considerably more. I don't know if the Bloomberg team is going to come in with millions of dollars against us at the last minute. I kind of think that perhaps with the Bruin decision, that they may see that would be spitting into the wind a little bit. But we believe Iowans will support this in the main, and we're confident about it. We're grassroots. We're just trying to defend liberty, frankly.
Well, thank you for meeting with us today. We appreciate your time.
All right. Well, thank you.
Thank you.
I hope you would maybe send me a link to this, because I don't have a subscription. You know, I'm down here in West Des Moines. I don't have a subscription. I went to look at the article yesterday that your reporter called me about, and I wasn't able to see it. But even if in the listing, but even if I had, somebody sent it to me this morning. Even if I had, I guess I wouldn't be able to read it. But I would appreciate a link at my email.
Sure, we can do that.